Hello. Thank you very much, Ivy. And I'm very happy to talk a little bit about downgrading from the EB2 employment-based category to the EB3 employment-based category this month. Ivy, will you be translating, or should I just go ahead with English the whole time?
Yeah, I think you can just continue. So if you have questions or you want Matthew to pause to explain further, please feel free to let me know.
Excellent. Okay. So in October, the priority dates for two backlog categories, the Chinese EB3 and the India EB3 employment-based categories, have advanced significantly, so that the Chinese dates for filing for the EB3 employment-based category has reached June 18th, okay? June 2018, all right? And in addition, the Immigration Service has said that the dates for filing will be used for to enable people to apply for the green card. Okay, so this is fantastic. As you may know, the wait times for employment-based immigrants, especially Chinese and Indian immigrants, have gotten very, very long. All right. However, this month, Chinese immigrants who have priority dates before June 1st, 2018, and you see that here in the lower right, June 1st, 2018. I don't know if you can see my my mouse pointer, but that's the current priority date, allowing people to apply for the green card this month. So if you are in an EB2 category, okay, and you have a priority date that is before October 2016, okay, that means you are not current in the EB2 category, okay? I hear, exactly. Very good. In the EB2 category, if you have a priority date before October 2016, okay, and you're Chinese, you cannot apply for the green card yet. You cannot apply to adjust status in the United States if you're here, okay? However, if if your priority date is before June 2018 in the EB3 category and you're Chinese, then you can file your application for adjustment of status or your green card application as shown by the EB3 category here in the lower right, okay? June 8, 2018, okay? So that means people who have priority dates that are before June 2018 and who are Chinese, okay, in the EB2 category or the EB3 category, of course, okay, can file their applications for adjustment of status in the United States. Note that Indian nationals also have a priority date in the EB3 dates for filing category that has advanced to January 2015. Okay, so people in the EB2 or EB3 category who are Indian who have priority dates before January 2015 can also apply for the green card this month. So if you have an EB2 approved I-140 with a priority date that allows you to apply for adjustment of status, okay, this month, and if you already have an approved I-140 in the EB2 category, what do you need to do if you want to apply for the EB3? Well, you must still have a job offer from your current employer who sponsored you for the I-140 and for the PERM. Okay, normally for the PERM. Okay, there's other ways to get an EB2, but normally you'll have a PERM approved and an I-140 approved with a priority date before June 2018. All right, and you must be in status, of course, in the United States. Usually you must still have an H-1B. You must be extending your H-1B and invalid status in the United States. All right, now what are the advantages for applying for adjustment of status now instead of waiting until the EB2 category is current? Well, you can get a work permit within 4 to 5 months and a travel document within 4 to 5 months, all right? And you will have a pending green card application, which allows you to stay in the United States, and you don't necessarily have to extend your H-1B or other non-immigrant visa, okay? O1 or L1, for example. And in addition, if the application, when the application is pending for 180 days, you could change jobs if you want to, without having to start the process over. So if you find a similar job, okay? That's something you should think about very carefully before doing that. Okay, there are risks, okay? But if the application, the green card application is pending for 180 days, you do have the possibility of changing jobs without having to start your green card process over, okay? So two very important advantages. All right, so if you're still working for your sponsoring employer who sponsored your EB2, and they're willing to help you file an EB3 application, and you still are in status, okay, there's two very good reasons to apply for the EB3 adjustment of status. All right, so what does that involve? Well, an EB3 adjustment of status application downgrading from an EB2 involves refiling the I-140, okay, and it involves then concurrently filing the I-45 adjustment of status application, along with a work permit application normally and a travel document application, and the new I-944 public charge application, okay, that Trump has instituted this year. All right, and this all needs to be filed before the end of the month, okay, before October 30th. And the I-140 requires all the same evidence that you filed with the original I-140, including a job offer from the sponsor, okay, and evidence that you qualify for the EB2 or EB3 category. You should qualify for EB3 if you qualified for EB2. Normally that means you probably have a master's degree, which would qualify you for EB2 and EB3, all right? And the employer must still show the ability to pay the wage, that they're still paying you the required wage, okay? So that's something to think about. Then, for the I-45 application, you have to provide a lot of personal information, your addresses for the last 5 years, your employment for the last 5 years, your taxes, your birth certificate, and all the information about any dependents that are applying at the same time. So another good thing about applying for adjustment of status is that you can also apply for the green card for your spouse and children as well, all right? But your children have to be under 21, and you must discuss that with us before you apply for your children. If they're approaching 21, there's some complications that you must discuss with your lawyer, okay, as well. But your spouse and children are also qualified to apply for the green card at the same time. And they'll need to provide birth certificates, they'll need to provide a marriage certificate, taxes, and all those things. So it's a lot of documentation, and we don't have a lot of time to do it, but there are two very important advantages to applying for a green card now. You'll have a pending application for adjustment of status, a pending green card that allows you to stay in the United States, okay, and work and travel, okay? And you also have the possibility to change jobs in 180 days after it's been pending, okay? That's something you should think about very carefully before doing that, okay? And I don't necessarily recommend it, but it is a possibility. So that is a good thing to have as an option, all right? So are there any risks to applying again? Can the I-140, can the second I-140 be denied in the EB3 category? Well, it could, okay? It shouldn't be, okay? If you qualified for EB2, you probably qualify for EB3, okay? But again, the employer does have to show that they are continuing to offer you the job. They continue to be able to pay you the required wage, okay? So if your employer is having financial difficulties, okay, or is not paying you the required wage, okay, then you need to think about that, okay, before deciding to file the EB3 application. And you still have to show that you are qualified for the category, that you have the required degree and or the required experience, okay? Normally, it shouldn't be a problem, okay? But if you had trouble with getting your I-140, your first I-140 approved, okay, please let your lawyer know. Now, if the EB3 is denied, okay, in theory, however, the EB2 that you already have approved should not be denied, okay, unless the Immigration Service decided that the EB3 is denied for a reason that would affect the approvability of the EB2, okay? If they decide that, for example, you did not have the required degree, let's say you have a Chinese degree or an Indian degree that's the equivalent of a US degree. If they decide that maybe the Chinese degree is not the equivalent of the required degree in the US, okay, they might be able to, might decide to revoke the EB2. Now, this is very rare, okay, but this is a possibility. That's something to think about. And Trump, especially if Trump's reelected, and we don't know what'll happen, okay, then he, you know, the standards for approval might change, okay, and become more stringent, okay. But in theory, even if the EB3 is denied, the EB2 I-140 application continues to be valid. So normally there shouldn't be a great amount of risk. Okay. So so this is a very good possibility for anyone who's qualified to apply for adjustment of status, who is Chinese and has a priority date before June 2018 in the EB2 category. Okay. You would need to get started right away. Okay. You need to let your lawyer know. You need to start getting the documents together to apply for the application and file the I-140 and the I-45 again, along with the work permit and travel document, as well as the I-944 public charge form for yourself and for your family members. So that's the basic introduction to the downgrading to an EB3 employment-based category. Ivy, do we have any questions?
Mm-hmm. Yeah, we do. Yeah, we received one question in the Q&A chat. So one of our attendees is asking, how long does the downgrade process usually take? And if my priority date is a few months after the EB3 cutoff date in Chart B, should I consider starting the downgrade process now or wait until the cutoff date in Chart B moves after my priority date? So the first question is, how long does it usually take, the downgrade application?
The downgrade, thank you, Ivy. Okay, very good question. Well, the I-140 and the I-45 may take a year or more to get adjudicated, okay? So preparing to file the application may take, 3 or 4 weeks. In order to file by the application deadline, we need to prepare the application in about 3 weeks. Okay, that's not much time. Okay, it has to be filed by October 30th. Okay, now the processing times for the I-140, okay, may be 4, 5, 6 months or longer. Okay, if the Immigration Service requests additional evidence. Now, the I-140 is eligible normally for premium processing, which allows you to get a response in 2 weeks. Okay, but normally for a downgrade application, premium processing is not available. Okay, so the I-140 in this case filed to downgrade to EB3 will probably take maybe 4, 5, 6 months perhaps, okay, to get adjudicated. Mm-hmm. The green card process, the green card application, which is filed along with the I-140, may take a year or more to be adjudicated. Currently, it takes about a year to a year and a half to get the green card interview appointment, okay, and actually get the green card. Now, the work permit and travel document should be approved in about 3 to 4 months, okay? But again, these processing times may vary.
Okay, got it. So the second part of the question, I'll just repeat. So if my priority date is a few months after the EB3 cutoff date in Chart B, should I consider starting the downgrade process now or wait until the cutoff date in Chart B moves after my priority date?
Very good question. Very good question. If your priority date, if you're Chinese and your priority date in the EB2 category is after June 2018, even a few months after, okay, you cannot apply this month. The priority date in the China column, in the China mainland board column, must be after your priority date. Okay, so if your priority date is after even a few months after the EB3 cutoff date in Chart B, you cannot apply. You must wait.
Okay. Thanks, Matthew. So yeah, if you have further questions about your application, you can contact us directly. I think that's kind of very sensitive information. You want if you keep giving us the information about your application. But yeah, so we have another question came in just now. So the next question is, when is the best time to apply downgrade? If filed together with I-485, if EB3 I-140 is denied, what should I do?
Right. Okay. So as I said, if you apply now, okay, you will have a pending I-140 and a pending I-485. If the EB3 I-140 is denied, okay, then the I-485 will also be denied eventually, okay? All right? Unless your priority date in EB2 becomes current, okay, and you can transfer the I-485 to the other approved I-140, okay? But that's a very complicated situation, okay? In the worst case scenario, if your I-140 is denied, your I-485 will also be denied, okay? But you should, and this is what we recommend, you should keep extending your H-1B, okay? That is ideal, okay? And then when your EB2 priority date is current, you can then apply for adjustment of status based on your EB2 priority date, okay? Assuming your I-140 in the EB2 category is still valid, okay? Like I said, if your EB3 I-140 is denied, it should not affect the EB2 I-140, okay? Unless the Immigration Service decides that the reason the I-140 was denied might also affect the approvability of the I-140 in the EB2 category, okay? Normally that shouldn't happen, okay? It shouldn't happen. Your I-140 in the EB2 category should still be valid, even if the EB3 I-140 is approved, however.
Okay, thanks, Matthew. So another question in the group chat. So also I want to remind everyone, 如果大家有问题的话，可以通过我们这个现在在微信群当中这样一个渠道，或者通过咱们这个 Q&A 的 chat box 可以发给我，我给带大家来提问。如果您想要直接跟 Matthew 律师来沟通的话呢，可以示意我，我可以把您 unmute， 然后这样我们可以来沟通。So the question in the group chat we received just now is, if the beneficiary or the applicant has a master's degree, would you recommend them to file EB2 or EB3?
Okay, is that the next one? The next question by Iris, is that the question?
No, actually the question I asked just now is what we received in a group chat. So if the beneficiary has a master's degree, would you recommend to file EB2 or EB3 application?
Well, if they have a master's degree, okay, they probably qualify to file under EB3 as well, okay, just as I've been saying, okay? If they have a master's degree, they probably qualify to file as EB3 as well, which is bachelor's degree or higher, okay? So they probably do qualify to file in the EB3 category, and that's what I would normally recommend, yes. Did I understand the question?
Yeah, I think you answered your question, but I think he sent over more questions, but let's take the question from in the Q&A chat box. So the question from Iris, while I downgrade to EB3 and the EB3 I-140 is pending, the EB2 priority date becomes current. Will I rethink the application to EB2? So the EB2 priority date becomes current. What should she do? Right.
Well, USCIS should use the current priority date if you have more than one, okay? Now, if they don't do that, and they should link your adjustment of status application to the current priority date, the current priority date that you have, okay? Even if it is a priority date related to your EB2 I-140, okay? Now, we can notify the Immigration Service to link your currently pending adjustment of status, okay, to the EB2 I140 that's already approved. Okay, that's what I would recommend in that case. So yes, you would ask USCIS to link the adjustment of status application to the EB2 I140. So it would get if the EB2 category is current and the EB3 category is no longer current. Okay.
Okay. Yeah. Sorry, I just read the question wrong. I already said, well, I relink instead of rethink. Sorry, I made a mistake just now. So the next question we received in the chat box. Can you please confirm if no premium processing for I-140, do I have to wait 6 months to get I-485 processed, or can I get the combo card before I-140 is approved?
Very good question. Okay, so there's no premium processing for the I-140 and the EB3 category if you are downgrading. That's absolutely right. But yes, the I-45 will be receipted, and it will be they will process it. Okay, they can't approve it until the I-140 is approved. Okay, and the final action date is current in Table A. Okay, but the work permit can be approved, and you can get your work permit and travel document after filing, even if the I-140 isn't approved yet, even if the adjustment of status is not approved. Okay, so yes, you can get your work permit in about 6 months. In 4 to 5, you can get your work permit in about 4 to 5 months. Okay, even if your I-140 is not approved.
Okay, great. Yeah, so the next question we have here is, should I submit the medical report together with the I-485 if I file according to basically the Table B?
Correct, yes. Yes, that's absolutely right. When you file the adjustment of status, the I-45, you must submit a medical examination. Okay, you should prepare that just before filing. Yes, you do need to file the medical exam. Yes, the I-6 entry, yes.
Okay, great. Yeah, so another question in the chat box is, so this attendee is saying, this question might not be totally related to downgrading from EB2 to EB3, but he or she is wondering whether the new rule on prevailing wage and especially occupation will impact the PERM application at all.
There is a new rule coming out about wages and about PERM applications. Okay, that is separate from EB. That is not related to what we're talking about right now. The specialty occupation rules are changing for H-1B visas. Okay, but that is not related to what we were talking about.
Okay, can you please maybe explain the new rule for a little bit? I think we got some inquiries asking about when the rule will take effect, and whether if they're having H-1B visa now, will their visa or wage be impacted?
Yes. The new rule will go into effect in 60 days, okay? Go into effect in 60 days, okay? And that will increase the required wage for H-1B visas substantially, okay? Probably for new H-1B visas and existing H-1B visas, okay? So yes, H-1B wages will increase substantially. Now, this rule is very last minute. There's an election going on. This rule will be challenged in the court. A lot of Trump rules have been invalidated, including the new increased filing fees and so forth. So I don't know if this rule will go into effect, but yes, the increased wages for H-1B specialty occupations is supposed to go into effect in 60 days, okay? The PERM application rules may also go into effect in about 60 days. But again, the PERM that won't affect PERMs that are already approved. Okay, that's going to affect PERMs that are new, that haven't been filed yet.
Okay, got it. We got a follow-up question from the first attendee who asked the question. So he or she is asking, with the approved EB2 I-140, is it possible to only apply for the downgrade but not I-485? So the applicant can hold 2 approved I-140s and wait to see which category gets current first.
Yes, that's absolutely possible. You can file a second I-140, okay, and then not filed the adjustment of status yet, okay? And then we'll have to wait to see if the EB2 or the EB3 categories are current again, either the dates for filing or the final action dates. Okay, so yes, you could do that if you don't want to go through the trouble of getting together the adjustment of status application this month.
Okay, let's take a question from the group chat. So one person is asking, does the pending PERM affected by the rule, by the wage? I guess the wage will be increased as prevailing wage rule.
No.
No, okay, the pending
ones that have already been filed should not be affected. No.
Okay, great. The next question in the chat box here is, considering the processing time, I just started the application process. Shall I apply the EB2 or EB3 now? Will the dates table be updated again soon, maybe next year? I think the next question, you can really follow us on the WeChat subscription account. USCIS or the government does release new dates or priority date every month, so you can check it out there. But the first question, Matthew, you may want to just explain again. I think it's really similar to one of the questions we answered earlier. He just started the application, so which should he or she go with, EB2 or EB3?
Right. Well, it depends on what you mean by you just started the application process. If you are just starting to, if you're just starting the PERM process, meaning the labor certification process, okay, that's the first step, okay, then you should talk to your lawyer about what the job requires, whether it requires a master's, which would put you potentially in the EB2 category, or whether the job just requires a bachelor's, which would only allow you to apply for EB3. Most people choose EB2, choose to use a job that requires at least a master's degree or 5 years of progressive experience, also may qualify you, so that they qualify for EB2. Okay, most prefer to apply using a job that requires at least a master's. Now, the employer has to agree. The wage is usually higher. Okay, so usually, if you're just starting the process, you're using a job that would qualify you for EB2 would be better. Okay, and then once you get the PERM filed and approved, not hopefully, okay, then when you file the I-140, you can look at the visa bulletin at that time, as Ivy said, and see what priority dates are current, EB2 or EB3, okay, if you qualify for both. And as Ivy said, the priority dates change every month. We'll get their new visa bulletins every month.
Okay, yeah, next questions I got from a direct message from one of the attendees. So he or she's asking, he has already talked to his employer and are ready to get the process started. I think it's PERM process started. So what would you need him or her to do next to really move forward with the application?
Okay, did you say they're getting ready to start the PERM process? Yeah,
I think he hasn't done anything about the EB3 or EB2 yet. So a brand new application starting from the very beginning.
Okay, well, the PERM process is pretty complicated. You have to first decide what job the employer is offering you, whether it requires a bachelor's or a master's degree. You have to request a wage based on that job from the Department of Labor. That takes 3 or 4 months. And then the employer has to conduct recruitment and show that there are no U.S. workers who are qualified and available for that job, okay? If there aren't U.S. workers who are qualified and available for that job, then the PERM or labor certification can be filed, okay? That takes many, many months, okay? You're at the beginning of the process, okay? You need to talk to your lawyer and see and discuss what documentation the lawyer needs to discuss the job description, okay, and the job requirements with your employer. That's the first step.
Yeah, I think it's kind of similar to H-1B application. We always want to know what exactly do you do? What's your job description?
Right.
Okay. That next question, let's combine those two questions from the Q&A chat box and from the group chat. So will chart B remain valid in November? And what if I cannot file the downgrade in November? So what is the deadline for filing the downgrade application?
Good. No, the November chart will no longer, the October chart, the chart B is the October chart, okay? This is the October chart, okay? It will no longer be valid in November. That's why if you want to downgrade to EB3, okay, and you want to file an I-140 and an adjustment of status application, it must be filed by October 30th, okay? Now, we don't know if the priority dates will still be as advanced in November. If you don't have time to file a new I-140 and or a new I-45 this month, okay, maybe in November the priority dates will still be advanced enough to allow you to file, okay? We don't know. But we won't know until the second or third week of October. We won't get the new November visa bulletin until a couple weeks from now, okay? So we don't know. Now, if your priority date is still current, okay, in November, then you can file your I-140 and adjustment of status in November, okay? But priority dates might go backwards, okay? It might not be current anymore.
Okay, thanks, Matthew. Let's take one last question I received here. So is it my decision or my employer's decision to do the downgrade application?
It's your employer's decision. They have to file the I-140. They have to sign it, okay?
Okay, yeah, so actually the whole PERM process, it needs employers to heavily involved. So I think the employer's agreement on this is very, very important. Right. Okay, yeah, I'm still getting a lot.
It doesn't require, the PERM process, which is the first step, requires a lot of work from the employer. The I-140 and the I-45 do not require as much information, okay, but it still requires, it doesn't require as much information from the employer, okay, but it still requires the employer's signature and information about the job, okay, and their finances.
Okay, thanks, Matthew. I'm still getting a lot of questions from the group chats and also the chat box, but I think we don't have time left for today. So yeah, if you have any further questions, please feel free to contact us directly. So we will try to help you after the webinar. And we do have my colleagues in the group chats. 所以大家如果要是还有这个后续的问题的话，可以在我们的微信群当中再继续提问，也可以跟小助手还有我们在群当中的其他的工作人员取得联络，来直接询问您比较直接 case 相关的这个问题。一方面保护您的隐私，另外一方面也可以更加直接有针对性的解答您的问题。那我们今天的这个 webinar 就到此结束了，非常感谢大家在线上的参与，也感谢 Matthew 律师对我们的解答。So Matthew, thanks again. That's all for today.
Thank you very much. Thank you, Ivy. Thank you, everyone. 谢谢。
Thank you, Matthew. Okay, bye.
Bye-bye.